So next we're going to take up 455. Sharon, if you would give us the explanation. Thank you.
Thank you, Mr. Chairman. This bill would create the offense of strangulation and the offense of aggravated strangulation. The bill would define strangulation as the restricting of a person's airflow or blood circulation by external pressure to the throat or neck, the blocking of a person's nose or mouth, or applying weight to the torso, abdomen, or shoulders as to restrict the person's breathing. Mr. Chairman, aggravated strangulation would be the offense would be aggravated if the perpetrator was subject to a was subject to a valid order of protection or restraining order, wielded a deadly weapon or ligature, or had previously been convicted of a strangulation offense.
Thank you, Sharon. All right, we got a few people who would like to speak regarding the strangulation. We're going to start with Lauren Moose. If you would raise your right hand for me, please. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you.
Good morning. I would like to thank you all for this opportunity. I would also like to give you a preemptive apology. I had a case that kept me until about 4 o'clock this morning, so I'm running on about 2 hours of sleep. So I don't typically like to read straight from my notes, but just so I don't miss anything, I'm going to try to stick to these. I'm a forensic nurse examiner with the McLeod Health Program in Florence. And we take care of patients that come in for various types of trauma, from sexual assault to domestic violence to non-domestic violence, human trafficking, and non-lethal strangulation. 1 in 4 females will experience IPV, that's intimate partner violence, within their lifetime. 68 to 80% of those will experience non-lethal strangulation by their intimate partner. Those of us that work with these patients have come to recognize that this is the most lethal form of domestic violence. There's a risk of death at the hand of their intimate partner, their risk of death at the hand of their intimate partner increases by 750% for a victim of one single incident of strangulation at the hands of that intimate partner. In its 2014 report, the U.S. Sentencing Commission even noted strangulation as a marker of dangerousness for the individuals that were being found guilty and put into prisons. And they even recommended an increased prison time of up to 10 years for individuals that had this history of strangulation in their backgrounds. Up to 92% of women who have experienced IPV, including strangulation, are estimated to have suffered some type of a traumatic brain injury. Up to 58% are strangled along with sexual assault or abuse. 9% of those are pregnant individuals at the time of the strangulation. Up to 43% of children have witnessed their mothers being strangled, and 9% of those children were strangled themselves. Up to 94% of strangled women believe that they were going to die. Up to 97% are strangled manually with either one or both hands. And up to 38% of those victims report losing consciousness. I'd like to very quickly walk you through what happens to a victim when they are experiencing strangulation. It can take about 2.5 minutes to kill somebody via strangulation. After about 5 or 10 seconds of pressure, external pressure to the neck, the patient will lose consciousness. This is because 4.4 pounds of pressure is all it takes to occlude their jugular. Those are the veins that actually return blood flow from the brain. So during this time, that blood flow is backing up in their brain. They're beginning to experience increased pressure in the head, ringing, whooshing sounds in their ears, bulging eyes, and petechia begins to form. 4.4 pounds of pressure, just to give you an idea of how small that is, it takes 5 pounds of pressure to crack an egg. It takes 20 pounds of pressure to open a canned drink. So less pressure to open your Diet Coke to actually render somebody unconscious. Another 6 pounds of pressure or so, bringing it up to 11 pounds, will occlude their carotid. Those are the arteries that actually feed oxygenated blood to the brain. So now the patient has no oxygen getting to their brain, and the blood that's been up there has no way to get back out. So again, they've lost consciousness at this point. After about 14 seconds, they will experience an anoxic seizure due to this lack of oxygen to their brain. Around the 15-second mark, they will likely lose bladder control. At around 30 seconds, they'll lose bowel control. At about 62 seconds, we hit the point of no return. This is when their respirations will either stop altogether or will begin the process of ceasing. They might wake up if their assailant releases the pressure and they actually come back to consciousness, but they will never have the same functionality that they had before. They will have had some sort of anoxic injury to their brain, likely some type of brain tissue death. They will have decreased cognition, decreased functionality in some form or fashion. At around 157 seconds, respirations will cease altogether. So 2.5 minutes doesn't really sound like a whole lot of time. But when y'all leave today, I'd like for y'all to take your phones and set a 2.5 minute timer and just sit there in silence and think about all the things that you can do in 2.5 minutes. Think about somebody sitting there literally watching somebody's life exit at their hands. The dangers of non-lethal strangulation are both short and long term. The most important of these, or the most dangerous, is a carotid dissection. When that pressure is placed on the carotid artery, they can cause it to rupture. It may form a clot to heal itself. However, days, weeks, months, even years later, that clot might dislodge, and then it can cause a stroke and either kill the patient or leave them with some severe deficits. Hyoid bone or damage. Your hyoid bone is a U-shaped bone that sits underneath the back of your tongue. It's not connected to any other bone in your body. It just kind of sits there. And it takes 6.9 pounds of pressure, and in some people as little as 2.5 pounds of pressure in order to damage or fracture it. We actually have a patient that we saw last year, and during the course of a sexual assault, and actually prior to that, she had experienced several incidences of non-lethal strangulation at the hands of her assailant. If my coworker had not been as insistent and diligent as she had, encouraging the ER doctor to perform a CT or order a CTA of her carotids, that hyoid bone fracture that she actually had suffered would never have been known. And she could have had some long-term difficulties from it, but more importantly, in lieu of a felony charge for that non-lethal strangulation, our solicitor was able to tack on attempted murder. And her assailant has now been denied bond twice and is still sitting in jail waiting for his trial. Swelling to the throat, neck, or tongue. So in this instance, we have a patient that survived external pressure of strangulation, and now they risk possible death from the internal obstruction of that swelling and choking. Seizures. We have a patient who recently reported that 2 weeks ago, his partner began strangling him, and he has suffered from a very controlled seizure disorder up until that point, but since the strangulations began 2 weeks ago, he's now had 5 seizures and has brought him to the ER several times. And if the victim happens to be pregnant, the definite risk is fetal demise. If mom doesn't get oxygen, the baby doesn't get oxygen. Traumatic brain injuries, we can see those as well thanks to not only the loss of oxygen, but also head shaking that can occur during strangulation. The danger of strangulation is definitely internal, and we see a lot of people who think that simply because there are no external injuries, then it must not be that bad. But the fact of the matter is that lack of external injuries does not mean an absence of lethality. In 50% of fatal cases, there were no visible injuries. Our statistics since we began in January of 22 have slowly increased. As of this day today, we have seen 122 patients in our program. 23 of those patients disclosed non-lethal strangulation. It is an increase from our last 3 years, and we contribute that to the fact that we are diligent on educating our law enforcement and our other agencies involved in the care of these patients that the lethality lies from inside especially, and just because you don't see injuries, you shouldn't minimize it and just tell the patient that they'll be okay. You need to make sure that they come and are seen. We are also educating them on the predictor value of strangulation. There have been a lot of studies and research that have shown that a majority of cop killers, domestic terrorists, and mass shooters all had histories of domestic violence with strangulation in them. A quote that I liked from the Police Chief magazine in November 22 said that research has now made clear that when a man puts his hands around a woman's neck, he has just raised his hand and said, "I am a killer." He is more likely to kill police officers, to kill children, and to later kill his partner. So when you hear, quote, "he choked me," now you know that you are at the edge of a potential homicide. I heard another police officer liken it to it is the DV equivalent to the DUI's odor of alcohol. On a DUI stop, if a police officer smells alcohol, he knows he needs to do some further assessments of that individual and ask more questions. So now our officers are learning that if a patient tells them he choked me, there are more questions that need to be asked in order to assess the potential danger for our patients and making sure that they are seen and receive the medical care that they deserve. I will leave you with another quote from Gail Streck. She is the Chief Executive of the Training Institute of Strangulation Prevention. This is a valuable institution that we get a lot of our information, a lot of our statistics, and that we utilize for a lot of our training with our law enforcement and our medical personnel. Statistically, we know that once the hands are on the neck, the very next step is homicide. They don't go backwards. It is the ultimate God complex for these individuals as they are sitting there choking somebody, or strangulating somebody to death.
Thank you. Senator from Spartanburg.
Thank you, Mr. Chairman. Ma'am, I was taking a few notes while you were going through your presentation. Just to make sure I heard the statistic correctly, what percentage do you say experience a traumatic brain injury after strangulation?
Up to 92% of women who have experienced IPV suffer some type of a TBI as well.
That's a pretty high. That's an incredibly high number. I mean, that's pretty stunning.
And it's our two. There are two folds to that. One, there is the lack of oxygen, but also our brains are basically floating in our head. It does not take as much force as a lot of times we seem to expect in order to cause any injury to our brains.
You said 4.5 pounds of pressure, right?
4.5 pounds of pressure just to occlude our jugulars, and 11 to occlude the carotids.
And it takes 2.5 minutes on average to
On
ultimately
average.
take somebody's life?
On average, for their respirations to completely cease, yes.
Wow. Okay, thank you, ma'am.
Thank you.
Any other questions? Thank you.
Thank
Appreciate
you.
it.
Mr. Chair, I don't have any questions for this witness. Anyone else's?
No,
wanting to
we got a
testify?
lot of people talking.
Okay, well,
Yep.
okay. Nope.
Next, Brian Bennett. Mr. Bennett and others, I'm going to kind of, we're crunched for time, so if we can kind of condense what you were going to say, but I know you got some experience with this as well, so give us the best analogy you can, please, sir. Thank you. If you could, raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God? Thank you.
Just real quickly, my name is Brian Bennett. I'm a retired state law enforcement officer. Taught 16 years at the police academy and specialized in non-fatal strangulation since 2015. I would just add a few points to the previous testimony. We know that there are at least 25 known medical complications with being strangled, many of which can lead to lifelong injuries and great bodily injury to late death. Some recent studies have come out through a survey of college-age students, and it revealed that 81% of college-age students have participated or have been subject to a strangulation event. So we're talking about our young people are at much higher rates of either practicing or being subject to this. Now, for individuals that say this isn't very serious, my rhetorical question is, if somebody was putting their hands or a ligature around your neck, what would you do to save your life? And most people, I've never had anyone say that they would not do anything less than fight for their life, which would mean they understand that there's some risk of serious bodily injury or death to defend themselves in that way. Another way to look at it is this: because of the great bodily injury and chance of death that is medically documented and proven that is associated with non-fatal strangulation, you are at a higher risk of this injury than someone shooting at you with a gun, which is a pretty startling statistic. I know domestic violence has been mentioned, and that is where the non-fatal strangulation education and training and research focused. But what I want to make clear is this is a comprehensive bill that would protect not just domestic violence victims, but our sexual assault, human trafficking, child abuse, our vulnerable adults, and with the increased risk of these individuals demonstrating homicidal tendencies, it also helps to prevent and identify those who would harm our law enforcement officers or create mass shooting events. I would like to mention real quickly, we have to recognize that the General Assembly has already established that this is potentially lethal. In 2023, the South Carolina Law Enforcement Reform Bill was passed, and in there it says law enforcement officers cannot use neck holds or neck restraints because it's qualified as deadly force. So it's already been recognized within that bill that this is inherently lethal, we need to take this and apply this standard across the board on a felony level. And the hope is that if we identify these individuals that utilize non-fatal strangulation, we preemptively prevent what we know are going to be future homicides. There are a lot of benefits to passing this bill. I can mention those if you like, but I would end it with this. I would like to suggest an amendment to this bill, and that would be to remove the consent language. The last sentence of this bill talks about if this was a consensual act. There's a few reasons why this doesn't need to exist. I will say that in the suggested wording of the bill that we have provided, the House and the Senate, that wasn't wording that we put in there because everyone, which is represented behind, we got forensic nurses, we got forensic pathologists, we got law enforcement victim advocates. A couple reasons is it's not necessary. If this act is truly consensual, law enforcement will never be notified, there will not be a criminal investigation, and there will not be any charges, for one thing. Also, we know that within the realm of interpersonal violence, there's often a dismissal of charges or cases because the victim fails to appear. This is true in domestic violence, but this is true in many interpersonal violence crimes. The Attorney General's opinion in 1997, backed by the Supreme Court and the state Supreme Court, have made it very clear. As long as there is sufficient evidence, it does not require the victim's testimony for the case to go forward. The consent language is essentially torpedoes every intent of this bill to save someone's life right out of the gate. Even in cases, and this is my personal experience, even in cases where we had evidence to go forward, some trial judges have dismissed cases just because the victim's not there, even though there was mounds of evidence that we could have presented. So that's one reason. A person cannot consent to be sexually assaulted or killed. It doesn't appear in any other criminal statute. And just because someone may consent to one activity with their intimate partner doesn't mean they consent to every activity. And essentially, whether it's consensual or non-consensual, the risk of bodily injury or death is still there. So that's my comments, unless y'all wanted to hear a quick list of benefits to passing this legislation.
Senator from Charleston.
Thank you, Mr. Chair. Question on that. So the last part where you want to strike the consent language. So my question there, so when I was reading that, I was wondering why it was in there, and I was thinking maybe for a couple that has odd things that they like to do.
Right.
But to your point of we don't need it because law enforcement wouldn't be called. My question is, if it stays in there, how you mentioned that it would torpedo. How would it do that if the victim will? I would think that if the law enforcement called the victim it's not consensual.
Correct.
Because you would report it as an assault, and so I don't see how it would torpedo it, but I just wanted to understand because I know I assume that's why that was in there because of those
People
instances.
don't want the state in their bedroom.
Right.
I get that. The reason that I would say with torpedo is because we know that there are coercive control methods of aggravated abusers to either influence the victim's non-presence in court or to influence their testimony after charges are made. And so if we simply use the consent language as the sole argument as to why
Okay.
this case should not go forward, then that eliminates and could possibly eliminate all the existing medical evidence from the hospital, any forensic evidence, or any other testimonial parties that could be involved. And again, in my practical experience as a law enforcement officer, 26 and a half years, some of my cases have been dismissed when I was ready to go with other evidence.
So the way I follow you is that the accusations made, the charges filed during the pendency of whatever, the victim then,
Recants.
calls
Or-
the solicitor. You know what? It was consensual. I was just upset that night, and so this would take away that element of it, right? Where the, I guess, prosecution could still go forward without having to consider that the victim then changed their statement?
And let's imagine this. Let's imagine that
Because they were coerced to change their
right, and let's imagine that did happen. That doesn't mean that the victim was at any less risk of great bodily injury or death. And to the quick question of, why don't existing statutes already address this? I've got 55 cases here reported in the media that show that our assault laws are not consistent with addressing non-fatal strangulation. We've got cases, even cases that I could personally testify to, where there was mounds of victim testimony, statements, suspect testimony and confession, physical evidence, forensic evidence, and charges were never made.
Okay, and then my last question, Mr. Chair, is if we take that out, then you mentioned the act that was passed about prohibiting law enforcement from neck holds, choke holds, and the like. Now, my question for that is, would that language that now gives an affirmative defense, would that undo that? Because now it says they have an affirmative defense if it was action taken by law enforcement. To me, that's a loophole to allow them to do the chokeholds.
Well, and I would disagree with that, because if you look at the provisions we made for law enforcement, it says it would be okay under the strangulation bill if law enforcement was doing it as a legitimate act of necessity. So it's not saying that law enforcement officers can't do it at all, but the simple fact is some law enforcement officers are not going to have their firearms or other impact weapons, and they may have to utilize a strangulation hold, essentially, as a means of self-defense, but a lethal form of self-defense. So we're giving our medical professionals, our law enforcement professionals, a window that would allow under special circumstances, as long as it falls within the bounds of the law.
Thank you.
Senator from Richland.
Sorry, Mr.
You're
Chair.
good. You're good.
What's your last name again, sir?
Brian Bennett.
Mr. Bennett.
Yes, sir.
Mr. Bennett, look, I'm not one who likes to Monday morning quarterback law enforcement's, actions, especially when you have to make split-second decisions in the field. That's not to say that law enforcement is beyond reproach or that you shouldn't be critiqued. And for the most part, I support this bill. But I guess to sort of piggyback off of what the senator from Charleston asked, and that is, do you foresee, strangulation or chokehold being used as a tool by law enforcement, or at least this subsection sort of opening the door for law enforcement to use that as a tool when subduing someone? I'm not, familiar with all of law enforcement's training. I've prosecuted in my legal career, but certainly I didn't go through the academy. But I have the utmost respect for law enforcement. But so my first question is this a tool that you foresee law enforcement using?
Well, to my understanding and in my experience, the reason that the law enforcement reform bill put that language in there was because it was used as just a form of control, not a need to use of lethal force, but to subdue and render someone unconscious so that they could be controlled in a less violent way. Essentially what the law enforcement reform bill is, it took away a tool simply to control somebody and only relegated and specified the chokeholds as a lethal force or deadly force necessity. So I don't see this particular bill opening up a window of now saying, okay, well, we've got the law enforcement reform bill passed, but you now have this carte blanche to just subdue somebody. I would point out that just the other day, our South Carolina Law Enforcement Division charged a law enforcement officer for using a neck hold or neck restraint that was not within the parameters of the law enforcement reform bill. So officers are being charged for falling outside what was passed in 2023.
Okay.
I don't think this would create a greater situation for that.
And lastly, and this is more so a statement, Mr. Chair. Mr. Bennett, I would respectfully disagree with you about the consent language as it pertains to, as far as the victim. And the reason I would disagree with you on that is the reality is you do have some people, or couples rather, that are just into some kinky stuff.
Correct.
And nobody wants their business in the bedroom, broadcasted, right? But we have sexual assault statutes on the books, and the defendant has the right to go into courtroom and assert, consent as a defense whenever he or she has been accused of a rape charge. And so for me, this is just sort of, consistent with what we're already doing. in our judicial system when you have someone that's accused of with sexual assault or what have you. And I also think that law enforcement or the state already has tools at its disposal if you have a victim that either retracts or no longer wants to go forward with the prosecution of the case. You can certainly have that person subpoenaed as a witness, bring them in and treat them as a hostile witness. And if judges are dismissing cases because a victim, because there's an affirmative defense, if you will, of consent, then we need to know about that. Because as far as I'm concerned, an affirmative defense, that's not tantamount to immunity from prosecution. Just means the individual has the right to assert that as a defense. So if we have judges that are throwing out, meritorious, cases brought by the prosecution, law enforcement, I certainly would like to know about it. Thank you, Mr. Chair.
Yes, sir. Thank you, Senator from Richland. Thank you, Mr. Bennett. I appreciate your testimony. Is there anybody here that wanted to speak in opposition to the bill? So because of time in that, I was going to, Senator from Spartanburg.
So, Mr. Chairman, for the sake of time, if there's nobody speaking in opposition, we're down to about 3 minutes before we've got to give up the room. So I would move favorable on the bill unamended. We'll take it to full judiciary, and any further debate can continue there.
Second. All those in favor say aye.
Aye.
Any opposed? So 455 is moving favorable to full committee. Thank you. And the last